we are going to talk about the limited liability partnership in company law. The limited liability actually helps you in terms of rearranging your internal structure. What happens in the case if a partner dies? It is a combination of company plus the partnership. Good morning and welcome to the second session on Unit 5. And here we are going to talk about the limited liability partnership in company law. Now, this is a very, very important session. Why? Because we are going to understand a different format of company called as the limited liability partnership. Now, is this format a very, very important method? Is it an upcoming ideology in companies? Let's have a look into it. Now, LLP stands for Limited Liability Partnership. So, is it same with that of the partnership kind of thing? No, actually, what happens here is that it is an alternative corporate business that offers benefits of limited liabilities to partners at low compliance costs. So what I would like to say here is that it is a different methodology which will give the partners a low compliance cost, which means to say that the overhead cost of running this kind of business is definitely cheaper. It's definitely better. You will get a easier method of doing this business, and the cost in terms of running the organization is lesser. It also allows the partners to organize their internal structure like traditional partnership. Like any other partnership organization, when you talk about a chartered accountant firm, a lawyer firm, an architectural firm, or about, let's say that you are going to talk about a judicial law firm, all these kind of factors are based on a partnership. So just like any traditional partnership, the limited liability actually helps you in terms of rearranging your internal structure as per your convenience. So there will be many people inside the organization who will work as partners. They will combine hands together. They will work as partners. They will try to support each other in terms of running the organization. So now what happens here is that as a partner, you become equally liable and responsible in terms of running this business. A limited liability partnership is a legal body. So let's first understand that, like any other form of company, the liability partnership is also a legal body liable for the full extent of its assets. So whatever assets have been employed, to whatever assets have been put into the business, they are fully legally employable and they are liable in that factor. Followed by the liability of the partner is limited. Limited to what? To the extent of the assets only. Hence, the LLP is an hybrid model. It is a combination of company and partnership. It is not the same like limited liability company. So this is where we need to get the difference factor. Now, when I talk about limited liability company, it is different from the limited liability partnership. But when I talk about limited liability partnership, it is a hybrid model. It has all the features of company plus the partnership model also. Hence, the limited liability partnership model is a very, very important concept that will try to drive you in terms of understanding a new business model, a new organizational structure altogether. Moving forward, let's now try to understand the LLP is a body corporate. What I mean to say that it's a corporate body which is having its own factors of understanding the nature of work. So now what happens here is that according to the section 3 of limited liability partnership, this is a body of corporate member formed and it is incorporated under the act. It is a legal entity separate from its partners. Now that is very, very important here. Why? Because when you try to understand the legal liability factor, like any other organization, like any other factors, they are the separate entity. They have all the rights, all the regulations that is being followed under the Companies Act altogether. Moving forward, the perpetual succession. So let me now get into the features of the limited liability partnership. What happens in the case if a partner dies? In the case if a partner is gone because some inconvenience altogether, if he resigns or if he goes away from the organization. So like any other general partnership firm, a limited liability can continue its existence even after retirement, insanity, insolvent, or even a death of more partners. Further, it can also get into contracts and hold property in its name. Now, there are many partnership firms that are available in India, many limited liability partnership firms that are there, where the partners will tend to continue the nature of business that they are following, in spite of the fact that if there might be any kind of emergencies or exigencies that come in their way. For example, it might be a death of a partner, or it might be in the case of insanity, or it might be in the case that one of the partner resigns and goes away, or it might be a scenario or a situation that all of a sudden there is an insolvency coming into picture. But then the partnership will continue, the format of business will tend to continue, and people will have to go into contracts. They will hold property at any given circumstances altogether. Now, moving forward, it is a separate legal entity, which I would always like to say, mention here. Why? Because just like a corporation or company, very, very important word. Why? Because as I have told you in the beginning, it is a combination of company plus the partnership. So just like any other firm, like a company, it is also having a separate legal entity altogether. It will hold a separate name, a separate format, a separate mechanism altogether. Further, it is liable, completely liable for its assets. So now it is a liability factor. It is not something that it can just go away with its asset. It is liable to whatever assets that are being employed there. Also, the liability of partners has a certain limitations in their contribution to the LLP, that is to the firm. So now what happens here is that for the partners, there is a certain amount of friction, there's a certain amount of restriction that it comes in terms of the holding of liability and to their contribution to the LLP. So they will have certain limitations which has to be followed, which has to be continued as per the given terms and conditions of the Companies Act. Followed by, hence the creditors of LLP are not creditors of individual partners. Very, very important point to be noted here. Now, the people who are providing loan to that limited liability partnership firm are giving loan to the firm and not to the individual partner. So it is not the responsibility of one individual partner who has taken the loan on behalf of the company. It cannot be misinterpreted like that. It has to be understood that the person is not responsible for the loans taken. It is the organization to whom the creditor has given. So all of them are equally responsible. All of them are a part of the investment. All of them are a part of the operation that goes through the firm. So that is why I would always say that it is a separate legal entity like any other company in this world. The limited liability partnership firm will have a separate name, will have a separate status, a logo and a symbol altogether. Followed by, It's a mutual agency. Now, this is a very, very important point that comes inside. Why? Because another difference between an LLP and partnership firm is that it is the independent or unauthorized actions of one partner do not make the other partners liable. Now, this is very, very important for us to understand. In a normal partnership firm, suppose one partner takes up any kind of unethical decision or takes up any kind of activity which leads to the loss of the firm or which leads to any kind of emergencies or exigencies that can make the firm come down, then automatically everybody will become liable. But in the case of limited liability partnership, one person's action cannot be made liable for every partners who are available there. Hence, that's why I always say that in the case of the limited liability partnership, what becomes very, very important here is that the partners, that is one independent partner's action does not make others liable. All partners are agents of the LLP. They are all working towards an agency. So they are all a member of that particular limited liability partnership. They all work together as a common team, striving for a common purpose. And the actions of one partner do not bind the others. So that is where if one partner's action will not be able to go and bind others. For example, there are many venture capital companies in India which work as limited liability partnership. Now, the people who are engaged in this limited liability partnership, the partners who are working in this venture capital, they have their own limitation, they have their own understanding and expertise about any business that they involve into. But at the same point of time, the decision taken by one partner regarding a particular business or a particular course of action will not have a reverberating effect on the other firm or on the other factor altogether. The reason being here very, very clearly told that in a limited liability partnership, the action of one partner is not making the other partners liable at any point of time. They are all individual, separate, but they work together as a team for a mutual purpose. Followed by the LLP agreement factor. An agreement between all the partners governs the rights and duties of the partners. So what are the partners actually involved into? How are they involved to? So there is an agreement, there is a contract, there is a right, there is a duty that is going to be designed, that is going to be clearly emphasized, saying that what are the rights and duties of the partner, what are they supposed to do inside the firm, what under what capacity each and every partner will be able to continue the operations. Followed by the partners can devise an agreement as per their choice. Now, this is a very, very important and an interesting factor also. As a partner of a firm, now what happens here is that all partners can devise the agreement as per their choice. So as per their working ability, as per their conditions, and as per their working phenomenon altogether, they will be able to devise the agreement. So somebody might be able to do the work a full-time basis, somebody might like to do it on an offshore basis model, somebody might like to work like a consultant basis, somebody might like to work like, a full-time, whole-time director basis. So there are kinds of agreement on the which they want to work with that organization. Followed by, if such an agreement is not made, now for example, between the partners, between the members, the partners of the organization, there is no consensus arrived, there is no agreement made at all, then the act governs the mutual rights and duties of all partners. Then automatically, as per the Companies Act, whatever that is being decided for LLP, limited liability membership, automatically that act becomes a immediate default action. So they come into that picture of the partnership work. Followed by the LLP motives. What are the motives of the LLP? What is that? Why they come into this picture? Why it becomes very interesting? The first thing that you need to know here is that Every limited liability partnership must at least have two partners, like any other partnership, and at least two individuals as designated partners. So when you are going to start an LLP, a limited liability partnership business, the first thing itself that comes to your mind that you need to understand, that you need to go through, is that there needs to be two people who have to be designated as partners, and there must be at least two partners already built in. Now, at any time, at least one designated partner should reside in India. So there must be one partner who should be a resident in India. That means, yes, he should be a citizen, he should be a resident of the Indian subcontinent. Now, there is no maximum limit for the number of maximum partners in this entity. So you can even have 200 partners or 2000 partners working around the globe. No worries about it. But then minimum of two, out of which one person designated should be a resident in India. Now, business for profit only. Now, at any given point of time, a limited liability partnership will be working only for business purpose and not for charity. So it is made very, very clear here that the limited liability partnership cannot be formed for non-profit or charitable purposes. At any given point of time, an LLP will not be formed for a charity purpose. So you cannot have a UNICEF model or a Red Cross model or a WHO model under LLP. That is not possible at all. It is essential that the entity is formed to carry out a lawful business on the view of earning a profit. So the entire ideology for starting a business here is very, very clear that we are entrusting ourselves to earn profit. We are not going to do this business for the sake of charity, for the sake of doing any other purpose altogether. Now, investigation. This is a very, very important factor. The power to investigate the affairs of LLP resides with the central government. So the central government will have a full power in terms of looking into what are all the activities of LLP. Now, for example, if I am running a chartered accountancy firm, or if I am running a tax consulting firm, or if I am running a law firm, or in case of an architecture firm, whatever firms which I am running all together, the central government will have the power in order to investigate, in order to find out whether I am been following the rules or if there are any deviations in form of the business that I have done in so many years. Further, they can appoint a competent authority for the same. So in case, let me now bring in the case of PricewaterhouseCoopers, or when they were caught in the case of Satyam as auditors, there was a case that was put across saying that the central government had nominated people to view into the Pricewaterhouse group altogether to check what the auditors did the mistake altogether. So the central government will send a competent authority or team who will investigate that limited liability partnership, find out the mistakes that they have done in terms of audit or in terms of legal or in terms of the consulting factor altogether. So definitely there is a checkpoint coming in from the government side, followed by compromise or arrangement. Any compromise or arrangement like a merger, amalgamation needs to be accordance with the Act. So as per the Companies Act of 2013, which is going to give in the command for the limited liability partnership, any form of arrangement, whether suppose let's say one firm wants to go and merge with other firm, or they want to buy out a firm or anything of that sort, then automatically that has to be given only by the Act as per the company law that has been prescribed, so that they can go further and they can enact accordingly. But they will not be able to do on an independent basis at any given point of time. So that is why it is very, very important to understand the concept of this limited liability partnership. With this, I come to the end of this session. I hope and believe that this session was informative, helpful, and of a great resource to you, both in terms of concept as well as in terms of your textual matter. Now, in the upcoming session, we will be talking about the Ministry of Corporate Affairs, which is the apex body in terms of running the corporate affairs, the industries, and the various banks and institutions all together in India. They are supposed to be known as the guardians of the corporate law. So we shall be looking into them in detail. Until then, stay tuned, stay blessed, and stay enlightened forever. Thank you once again for joining me on this wonderful session today.